The House.
I call the Honourable Leanne Dalzell.
Mr Speaker, as my colleague, the Honourable Phil Goff, has already said, Labor will support the bill to Select Committee. As a member of the Justice and Electoral Select Committee, I'm very pleased to see that it's going to the Law and Order Committee. There are obviously going to be significant issues that the Select Committee is going to have to address. And I think my colleague started off by highlighting those that are set out in the regulatory impact statement. And the regulatory impact statement on its disclosure statement at the front makes it very clear that the government is basing its decisions without any real knowledge of either the fiscal costs or the benefits of the options. And I mean, that's a strategy that a government can adopt, and it does kind of tie back to the reason why we're actually debating this bill. But I think this is something that will be explored at the Select Committee. So the statement from the regulatory impact statement says this: the expected fiscal costs and benefits of options can only ever be approximate, as there is no foolproof way of predicting how the policy change will influence the court's exercise of discretion and which defendants will offend on bail and the extent to which serious offending on bail is reduced. And when one turns to the back of the regulatory impact statement, a very interesting analysis of the specific offences and the proportion that serious offences represent in terms of the total number of offenders who offend while on bail. And of course, if we were thinking about this legislation that we have in front of us today, we'd expect that bar that goes right out to the end to be one of the very serious offences, of course, included in this legislation, but actually they're much more likely than anything else to commit a traffic or vehicle regulatory offence. Another offence committed while on bail that certainly goes up there are offences against justice procedures, government security and government operations, and justice procedures is no doubt not complying with the provisions of their bail and perhaps not fronting in the court when they're required to. The next one down are theft and related offences. It's only when we get down to 11.4% of the most serious offences committed on bail that we start to get acts intended to cause injury. So I think it is important, when the Select Committee is considering the detail of it, is to actually look at what offences are committed while people are on bail, and to remember the presumption of innocence until proven guilty as part of the analysis. So I'm not saying that we're not going to support the bill as it traverses through the House. I'm just saying that there is a responsibility on members of this Select Committee to look very carefully at this detail and report back to the House accordingly. Because what the regulatory impact statement cautions is that there are a number of assumptions and caveats used to assess the fiscal costs and benefits of each option. So there are some costs that are included in the regulatory impact statement. I'm going to come to those, and some of the benefits aren't really known. Well, I think the member's interjecting that it doesn't matter what it costs because, you know, keeping people safe is the priority. And that might be the conclusion that the government reaches, that they're prepared to lock everyone up who's charged with an offence of this nature. Now, I know that's not what their bill does, but it's all very well to say that it's not relevant to look at the question of costs and benefits. That's what a regulatory impact statement does. Mr Speaker, in addition to the fiscal implications, policy options that involve increasing the use of reverse burdens of proof in bail decisions, as my colleague has highlighted, also require, and this government has said this itself, it's restated in the regulatory impact statement, will require a particularly strong case before regulation is considered. Reverse burdens of proof may override the following fundamental common law principles and rights guaranteed by the New Zealand Bill of Rights Act, namely that a person charged with an offence is to be considered innocent until proven guilty, and that no person shall be arbitrarily detained. The issue is then also raised in this regulatory impact statement about amendments to youth justice provisions also potentially having implications for New Zealand's obligations under the UN Convention on the Rights of the Child to ensure that children under the age of 17 are detained only as a last resort and for the shortest possible period. I'm simply highlighting these facts from the regulatory impact statement because it is going to be important for the House to address them and certainly for the Select Committee to consider them because they will be issues that will be raised at Select Committee. And the last thing that we want to see happen is for changes to the law to be made in order to look like something is being done to address something that people are fearful of, but actually not make any difference at all. We've had actually a drop in our crime rate in real terms every year in this country since 1995. The crime rate has gradually been coming down. And that's, I think, a much more interesting issue because if one considers whether we would rather have bail laws affecting or changes to bail laws affecting people who've already offended or actually making a difference in terms of the amount of offending that's happening in the first place, well, I know that where I'd like to be putting my effort, and that's certainly into those drivers of crime which lead to lead to the crime rate. And I actually think that this House is going to be facing a very serious challenge to whether the government is prepared to make a difference in terms of our crime rate when we come to the alcohol reform bill, because we all know that the changes that are being promoted in that particular piece of legislation do not meet the very strong bar that the Law Commission set when it undertook its very evidence-based report to the House, basically ensuring that we were aware that if we could make a difference in terms of the amount of alcohol that was being consumed, that we would end up having a huge impact on our crime rate because so much crime, domestic violence and other offences are committed while people are under the influence of alcohol. So that's going to be the challenge to this House. It's all very well to talk about the bail legislation, but when it comes down to the fact of how people vote on amendments that we're going to be putting on the alcohol reform bill, then I think the members on the other side of the House will be called to account by their own constituents. This will not have the impact that changes to our alcohol laws would have. Mr. Speaker, this regulatory impact statement also goes through the question of the individual offences that have been chosen. And there are a couple of offences that I just want to highlight to the House because what the Justice Ministry has done is that they've set out the risks around the status quo and then they've set out different options. And the options 1, 2 and 3, and then they've highlighted which is their preferred option. So when we come to defendants charged with serious Class A drug offences, the preferred option is to reverse the burden of proof for defendants charged with serious Class A drug offences. The other options that they looked at were an amendment to Section 10 of the Bail Act, looking at those who had a history of serious violent sexual or Class A offending, and option 3 was to prohibit defendants charged with serious methamphetamine offences. The preferred option was option 1, just reversing the burden of proof for defendants charged with serious Class A drug offences. This is what the cost is. The cost could result in a significant number of defendants being held in remand who would not have offended on bail or would not be convicted of the offence charged. It's likely to be the least justifiable infringement on defendants' criminal process rights, and the fiscal cost to the Department of Corrections due to increased defendants in custody of $774,000 per year, or the equivalent of 8.5 prison beds. It was $774,000 per year, $750,000 for an estimated 7% reduction in offences committed on bail by defendants charged with serious Class A drug offences, which is a minor number of offences when compared to the total number of offences which I showed to the House before. So I think there is going to have to be some serious consideration of all of these factors and not just get bound up with the hype around looking like one is tough on crime. If one really wants to be tough on crime, then the Alcohol Law Reform Bill is the one to use.
I call the honourable member